Wait a second. No fight, no warning, and suddenly a suicide? That doesn't just raise eyebrows, it screams inconsistency. If the story starts shaky, imagine what's coming next.
I'm trying to connect the facts. It doesn't make sense if there was no fighting, if there was no negativity, if nothing occurred, and all of a sudden some girl with beautiful black curly hair and huge, delicious looking cleavage, and a statement is made that the woman would go and all of a sudden go home and nothing else occurred. She would grab a .22 and shoot herself in the head in front of her significant other without a statement made. All right, okay. We will go on the record in the matter 23 CF 213, State of Wisconsin versus Bradley Scheuer. This date appears through Assistant District Attorney Holly Rockow in person. We have Mr. Scheuer appearing in person in custody with counsel Glenn Keene. We're set here today in this matter for a sentencing hearing after revocation. Mr. Scheuer was placed on probation after he pled guilty back on September 3rd, 2024 to one count of possession of a firearm by
3 days. That's all it took. Probation is like a fragile lifeline, and breaking it so quickly almost guarantees revocation. Judges rarely go easy after a slip this fast.
A convicted felon. 3 days after he was placed on probation, he was put into custody for another serious offense in which he was just recently sentenced. He was revoked on this matter due to the allegations and matters in the case that he was just previously sentenced. This matter was set for a revocation sentencing. The court has received and reviewed the revocation order and warrant packet from the Department of Corrections. I have reviewed such packet, and in my review, I could not see any material facts or statements that need to be clarified on the record. But again, I don't know all of the information that the attorneys know to be able to have those material facts and corrections jump out at me. Ms. Rockow, as Assistant District Attorney, are we in victims' rights compliance?
Yes.
Did you review the revocation order and packet in order?
I did.
Any material facts or statements that need to be corrected on the record?
No, Judge.
Is there going to be a victim impact statement made here today?
No.
Okay. Mr. Keene, did you receive and review the revocation order and recommendation packet?
Yes, Your Honor, and there are no facts in there that I believe need to be corrected.
Did you review that thoroughly with Mr. Scheuer?
Yes, Your Honor.
And he did not discover or find any material facts or information that should be corrected on the record?
But no, Your Honor.
Okay. All right. Thank you. Ms. Rockow, please begin your sentencing argument and recommendation.
Thank you, Judge. The state respectfully recommends that Mr. Scheuer be sentenced to
4 years might sound light compared to the 10-year max, but remember the galleon factors: seriousness, character, and public safety. Which one do you think weighs most against him?
the state prison system for a total of 4 years, with 2 years of initial confinement, 2 years of extended supervision. That is in line with the recommendation that was outlined in the PSI by the department. As the court's aware, we are to consider the galleon factors here in determining an appropriate sentence for Mr. Scheuer. The state's position is that Mr. Scheuer must be sentenced to prison based upon the factors. As far as the gravity of the offense, possession of a firearm by a felon is very serious. The legislature indeed has deemed this a Class G felony with a maximum possible penalty of 10 years. It's a crime that poses a serious risk to public safety. This crime in particular, the underlying facts of this case warrant a prison sentence. Mr. Scheuer was, at sentencing, there were 4 other counts that were dismissed but read in. including 3 counts of possession of a firearm by a felon in addition to this conviction. There were 4 total rifles that were in Mr. Scheuer's possession at the time of this incident. And on the date of that arrest, he admitted, and in fact, one was in his direct control, very nearby to him, and he had admitted to law enforcement to having handled that firearm in particular on that date. He also had a knife concealed in his possession. So this is an inherently serious crime, and the facts are also quite serious in this case. In terms of the character of the defendant, again, inherent in this crime is an indication that the defendant has no regard for the law. He's a convicted felon, not allowed to possess firearms, and he did so anyway. His criminal history reflects convictions dating back to the early 2000s. He has a fairly extensive history. His history does include violent offenses, convictions for battery, simple battery and substantial battery, violations of domestic abuse no contact orders, also includes recklessly endangering safety, and multiple convictions for bail jumping. I'll also note that there's a 2014 conviction out of Minnesota for possessing a pistol or assault weapon. The need to protect the public is the last factor for the court to consider, and I think that there's an obvious need to protect the public from Mr. Scheuer. A convicted felon with a violent criminal history who shows no regard for the law, no regard for court orders, or for the public, or for public safety. His actions that led to the revocation obviously include more violence, more disregard for public safety and for the law. I think anything other than a commitment to the state prison system would unduly depreciate the seriousness of the offense and the conviction here. And I do think, in fact, prison is necessary to protect the public in this case. Thank you.
All right. Mr. Keene.
Your Honor, I do have one character witness for him. It's his son, Brandon Scheuer, who's here in court.
All right. Miss.
Here's the emotional play. A son defending his father. Powerful, right? But the question is, does the court see genuine concern or just another excuse to soften a repeat offender sentence?
Mr. Scheuer, you can come have a seat over at the black table, and you can state your name and spell it for the record.
Just be fast. Hello, hear me? My name is Brandon Scheuer. It's Brandon Scheuer.
You may begin.
Where do you want me to start? Glenn.
Nope, you just.
Whatever you talked about.
Oh, whatever I talk about.
Yeah.
All right, well, I'll start off by saying that, I do think that violent criminals should be in prison. I don't think my dad's a violent criminal. I think that he has mental health issues that were never addressed for the last 20 years. And I do believe alcoholism amplifies those. And I believe getting mental health would help him dramatically. In the case of this issue, I could tell my father was a different person after the suicide. My father always had like a clean counter, dishes always done, up early. I would not hear from him for a couple days after the incident. I would go check on him. He would still be in bed with a giant body pillow, counter trash, sink full of dishes, just completely not his character. And I believe that was just more depression. And I think that his depression and his mental health issues have never been addressed. And he's constantly been incarcerated and never gotten help that he's needed. And I think getting him the help he needs is a big step. Is he going to have to be in prison? Yes. but just locking him up isn't going to help him. He needs to get help. And I wish the court system would help more people in this case. It's an epidemic in this country where people are just locked away when they have issues, and we don't address the mental health issues that we need to address. 3 of those guns that were locked in the shed on the day of that incident were mine for deer hunting. I had them locked in that shed. I believed I had the only key to that shed. I was unaware there was a second key. The .22 firearm that was used in the incident, to my knowledge, was used for protection against bears as they were living in my camper on his 40 acres. When Crystal and my father first started staying on the 40, they were staying in a tent. They had bears tear the tent, tear the coolers. I gave them my camper to stay in as a safety option. Other than that,
This is the bigger debate: justice versus rehabilitation. Should courts focus on locking away dangerous offenders or fixing the root problem like untreated mental illness? It's a dilemma that goes way beyond this single case.
the only real things I have to say is that I believe that this country has a problem with just locking people up and throwing them away. And I think that we need to address mental health issues more and more in this country. And this case in particular, he's had 20 years where he's never had that addressed. And he grew up at a time where when people had mental health issues, they really didn't talk about it or get addressed. And I believe most of his issues stemmed after the divorce with my mother in 2003. His alcoholism, which he hadn't drank in many years, had kicked off and came back into his life and continued to amplify those mental health issues. Because when people are depressed, the drinking don't help that. All it does is amplify those issues. And that was never, ever addressed in over 20 years of him being in and out of the system. That being said, I can't quite think of too much other things to say. I know my father is a very good person when he's not drinking. He has donated his time to my business during the parades and other things, and to help me with working with kids in the community for kayaking. He cuts and splits wood. He has helped friends of mine who needed trees removed or other things on their property done come over without even being paid to help out, just to be a good Samaritan. So I know there's good in him. We're not unlocking the good. We're locking the good up with the bad. Where we should lock the bad up and unlock that good. And the only way that is to use, mental health therapy and other sorts of programs to get to the root of the problem. I went through therapy because of you, Judge, and I continue to do that therapy for a while after the things we had with the things I did to get back, and it helped me very much. I come creating new programs to help myself hydrate more, things like that, getting better eating schedules, just slight things to add more consistency to life and a more routine schedule. And I think, that helps a lot of people. And it's something I needed just slightly to help my life, but there's a lot of people that need a lot more than that, and they need that intense mental care, and that's something this country has gotten far, far away from. And I hope we get back to it.
Thank you, Mr. Scheuer.
Thank you, Your Honor.
All right, Mr. Keene.
Yes, sir. When we look at this case and sentencing and the factors, I think a couple of things to note. Well, I won't dispute the seriousness of the crimes because Mr. Scheuer does have a lengthy criminal record. Most of it is for, substance abuse related issues, but you've seen that on pages 24 and 25. So, I won't dispute that. However, when you look at the character of the defendant, I would note that when you look at the offenses that day, his son had just talked about how, the 3 of the firearms were his, and it was, a place to hunt in the 40 acres. And he said that they were encased. I would note that my client on the day he was charged, had contacted law enforcement. He, pointed out, the weapon was not in, was set by the vehicle when law enforcement arrived. He's not brandishing it. And his son had just testified that the .22 was, for, protection for bears. A .22 isn't usually a weapon if you're going to try and rob somebody, a .22 isn't your first choice. And regarding the dismissed and read in on the concealed knife, it's a 40-acre property, and, he had it. There was nothing about him threatening to use it.
But I'm hearing excuses. He's a felon. He's a felon, a convicted felon, and I'm hearing excuses. Even in your defense argument, they're excuses.
I'd see them as mitigating factors rather than excuses.
There's other things to use to protect against bears. I've done it myself. I've grown up in bear country myself. I don't carry a .22 or a knife. There's bear spray. There's crossbows. There's other things that felons can use and carry. It's an excuse.
Well, and these guys, the firearm was owned by the person who lived there, not him. But I get that when you live with you're a felon, and the person you live with has a firearm, it tends to put you in an untenable situation.
And he admitted to operating it.
Right, moving it. Okay. But I think we did point out in needs is that, the alcohol and counseling needs, and he did talk about one of the things looking at revoked is that unfortunately, mental health needs did increase after that because his son did describe a change in my client's behavior after his then girlfriend unfortunately, took her own life that day. And, that obviously contributes to a downward spiral as well. And I would note that, when you look at protection of the public, I would note that, he already, for the offense he was, convicted, pled to in this court, he already had a 9-month sentence. And I think that, allowing him to be closer to his son and the community would probably do more in the long term to protect the community than just simply warehousing him again, which is what his son was saying, because, it access to, counseling and other needs. So the defense thinks that, a reasonable sentence would be 9 months of custody, because he already has a 9-month sentence in 24 CF 202. So if you sentence him consecutive that, then he's still closer to his family and other things, and hopefully could address his needs. And, if he qualified for Huber, he'd be in a confined setting, because obviously if you're, having to go to and from jail or report on monitor, that would be a way of ensuring sobriety, because when for the charge he was revoked, he admitted to having alcohol that day. So